My name is Dr. Fiona Hum and I'm the lead author of the textbook Australian Uniform Evidence Law. It's going into its third edition. The idea for the textbook emerged from over 20 years of teaching evidence law and the ongoing frustrations of not having a student-focused resource. Existing materials were either extremely dense and inaccessible or too simplistic and vague, so none of them really provided an easy, comprehensive explanation of key concepts, nor offered students the opportunity to apply their understanding through practice. So as a core unit in the Bachelor of Laws degree, the evidence law includes specific topics that have to be taught, and many students find the unit quite challenging, technical and complex. The textbook was therefore intentionally designed for students encountering evidence law for the first time, particularly in the evidence law jurisdictions such as New South Wales, Victoria, Tasmania, ACT and the Northern Territory. Teaching a final year evidence law unit gave me a clear understanding of the academic standard required, as well as the pedagogical strategies that best support student learning. So I intentionally designed the textbook to reflect effective teaching practices, breaking down complex concepts, using problem solving to illustrate key ideas, and presenting context and content in a clear, accessible format. Some key features include definitions of key terms at the end of the chapters. Legislative extracts and case law set out clearly in easily identifiable coloured text boxes. Recommended readings at the end of each chapter, inclusive of problems for students to practice their independent study and newfound knowledge. A comprehensive final problem that integrates all of the multiple topics and concepts. So these elements were included to help students consolidate their understanding and develop critical thinking skills and problem-solving skills essential for legal practice. So this edition contains a number of updates on recent appellate court decisions from the uniform evidence law jurisdictions that interpret and in many cases expands the scope of admissibility or exclusion under the Evidence Act. I included a Section 75, which is an interlocutory proceeding, and the hearsay rule doesn't apply to evidence if the party who adduces it also adduces evidence of its source. So there's a case that talks about an order for a permanent stay that was an interlocutory proceeding. I thought this was important because many of my students actually perform oral submissions that involves interlocutory applications. Another example is in relation to expert evidence. I think that the Victorian decision of Tuart now has to be read in light of the new High Court decision of Im and the Queen. Im and the Queen states that issues of reliability and credibility are not to be considered when assessing the probative value of the evidence. Under the chapter of admissions, the phrase investigating official has been expanded to include employees of a casino employed under the Casino Control Act. But the most significant amendments and updates have actually been in relation to tendency and coincidence evidence. For example, there is a new High Court decision that explores whether tendency evidence adduced could be used to prove the identity of the offender. It was a case whether the threshold of significant probative value was capable of being met without close similarities. But it was the Royal Commission into Child Sex Abuse that produced a number of important changes, particularly in those jurisdictions such as ACT, New South Wales, Northern Territory and Tasmania. There was an insertion of Section 97A, which admits tendency evidence in proceedings involving child sex offences, which is presumed to have significant probative value. Moreover, Section 98(1) has also been inserted. This is in relation to evidence of two or more witnesses claiming that they are victims of offences committed by the defendant that is being adduced to prove similarities between the claimed acts and the circumstances in which they have occurred. This is known now to be a type of coincidence evidence. Notably, I've also included for recommended reading insights from my own recent publications to encourage students to engage with critical analysis and to extend their understanding of very controversial issues studied in the unit. The case of Cardinal Pell explores the prosecution and ultimate acquittal of Cardinal Pell, demonstrating the High Court's reasoning on the burden of proof that must be established. So this analysis explores the High Court's reasoning and the presumption of innocence. It has implications for criminal trials and our criminal justice system. The case of Kathleen Folbig involves Kathleen, who was wrongfully convicted of the murder of her 4 children and had spent 20 years in prison, draws upon the tendency and coincidence reasoning, which is in one of the chapters of the textbook. This article investigates the systemic failures, if you like, that led to the wrongful conviction and the broader consequences of such miscarriages of justice. I've also included an article that I've researched into oaths and affirmations. This research critiques the traditional swearing-in process, highlighting how it can be quite exclusionary, if not discriminatory, to particular groups, especially for cultural and religious minorities. It examines the assumptions that judges and often counsel make, especially through cross-examination, to undermine the credibility of witnesses in terms of the choice of oath or an affirmation. So it's hoped that these additions to the textbook deepen students' understanding of how evidence laws operate in real-world contexts and provides their engagement in critical analysis with law reform and practice. So there are several trends that are basically reshaping the landscape of evidence law. For example, electronic and digital evidence. This is becoming increasingly central in many criminal trials, given the volume of data being generated. It also impacts on criminal trials involving fraud or breaches of cybersecurity. Another example would be generative AI. This is now capable of producing reconstructions, summaries, even argumentation, possibly, raising questions about the reliability and admissibility of such evidence. I think these developments place a greater responsibility on legal educators and practitioners to teach students how to critically assess the reliability of digital evidence, challenge its admissibility, and understand when expert testimony may be required. I'm hoping students come away with a solid, practical understanding of evidence law, one that not only prepares them for exams, but also equips them for the real world and legal practice. I want them to feel confident in navigating complex legal principles, applying them to factual scenarios, and thinking critically about the evolving nature of evidence in our justice system. Ultimately, the book is designed to empower students to become independent learners, thoughtful practitioners, and this goes beyond doctrinal application of the law.